Yes.
Jurisdiction ठीक है para 24
No,
में
your
child
lordship,
return within 30 अच्छा this is sir.
This is the order that within 30 days she has to take the child back to Canada. Para 24.
ठीक.
If your lordship para 33 also, please see para 33.
What has happened after the expiry of 30 days?
No,
what
if the respondent does not return the child, the child shall reside exclusively with the applicant, that is with the father.
Have you filed any execution proceeding?
No, I'll file habeas corpus. I'll tell you why. Because latest judgment.
You want this court to become an executing court of the Toronto?
I know, Malad, that argument was coming. I'm totally covered in law. Totally. And now there are 6 judgments of the Supreme Court. Where the moment you have an order of a foreign court, the custody will not be illegal. But it will be unlawful, contrary to a court order of a competent jurisdiction. Today, they cannot say that Canadian court has no jurisdiction. And they did not file an appeal against the 12th July order. My lords, in the Canadian court. Today, the Committee of Court respects your lordships in 226. Your lordship is correct. Your lordship can decline the repatriation. But your lordship will have to come to a conclusion that it is not in the best interest or there is a harm to the child. The child has been living in US and Canada since the inception of her birth. And my lords, Justice Deepak Gupta's judgment, para 32 of Yashita Sahu, they clearly say, why did you take the citizenship of US? Now you cannot devoid the child of the facilities of the US country. Today, my lords, not even the US citizenship, but permanent residency of Canada. Today there is a marital discord. You run away with the child and say India is the best place because it is not a signatory to the Hague Convention. Otherwise, 103 countries, including Pakistan and Sri Lanka, are signatories to that, and the child below 16 years has to mandatorily return to his native country. The native country of the child is Canada today. Now, my lords, please see the order. Para 35 for a minute. Para 35. I make these orders.
Yes.
Third line from top. I am not persuaded by the respondent. Your lordship has evidence that the child is in great harm, let alone any harm while in the applicant's care. The respondent's allegations were self-serving and unsupported by any objective evidence. Direct finding to that behalf that there will be no harm. While the child may have witnessed arguments between the parties, I am satisfied that the parties living separate and apart, the prospect of reoccurring is minimal. I am not persuaded that the applicant's receipt of therapy from a psychologist to assist him in managing his emotion is a cause for concern when the child is in the applicant's care. Then, Manoj, page 440, the applicant seeks an order that this court decline to recognize any Indian orders. Then, Manoj, what happens is, para 37. There were about $220,000 of the parties in a joint account. So the wife took some money from the account of 30,000 while leaving, my lords. So the court says whatever the balance is there, the husband had also taken out some money from that. The court said no, the husband will deposit $220,000 in an account with his lawyer, and that will be maintained. And from that money, she will be given and one escort. They will come to Canada and their expenses will be taken care of. That Canadian court also does that. Now, my lords, what happens is, this order is 12th of July. Pursuant to this order, no appeal is filed. This is corrected on 21st of July. There was some factual error. It was corrected. Now, my lords, pursuant to that order, they did not file an appeal. And my lords, one more thing is there. They have acquiesced, participated in the proceedings in the Canadian court. So today they cannot say it is an ex parte order. Though Justice Chandrachud in one latest judgment has even repatriated in an ex parte order. But, my lord, what I submit
Mr.
is...
Counsel, last date also I wanted no need to take name of judge.
Okay, my lord, I'm sorry.
Supreme Court is Supreme Court.
Yeah, okay. Supreme Court judgment.
No
latest judgment, 3-bench judgment.
Yes.
I'm sorry, I stand corrected, sir. So, a 3-bench has recently held in 2020, my lords. Now, my lords, what are my arguments, my lords?
Yes.
My first argument is, child has been a resident of USA in Canada. The husband has been a resident of US in Canada since 2008. And, my lords, pursuant to the marriage on 18/1/2014, and the wife knew prior to the marriage that she has to settle abroad. She visited him even prior to marriage. So she knew that she is going to settle overseas. So 18/1/2014, she has been residing in the US and Canada. 18/1/2014, my lords. And then my third point, for delivery